Let me make it clear. The legal risk, as I set it out in my letter of the 13th of November, remains unchanged. The question for the House is whether, in the light of these improvements, as a political judgment, the House should now enter into those arrangements. Let me move on to what these documents do achieve. As I set out in my opinion, the joint instrument puts the commitments in the letter from Presidents Tusk and Juncker of the 14th of January 2019 into legally binding form and provides, in addition, useful clarifications, amplifications of existing obligations, and some new obligations. The joint instrument confirms that the European Union cannot pursue an objective of trying to trap the UK in the backstop indefinitely. The instrument makes explicit that this would constitute bad faith, which would be the basis of a formal dispute before an arbitration tribunal. This means ultimately that the protocol could be suspended if the European Union continued to breach its obligations. The joint instrument also reflects the United Kingdom and the Union's commitment to work to replace the backstop with alternative arrangements by December 2020, including as set out in the withdrawal agreement. These commitments include establishing, and I quote, immediately following the ratification of the withdrawal agreement, a negotiating track for replacing the customs and regulatory alignment in goods elements of the protocol with alternative arrangements. If an agreement has not been concluded within 1 year of the United Kingdom's withdrawal, efforts must be redoubled. In my view, Mr. Speaker, as a matter of law, the provisions relating to the timing of the efforts to be made in resolving withdrawal agreements makes time of the essence in negotiating a subsequent agreement. A doctrine with which the lawyers in this House will be familiar is of legal relevance. In my view, the provisions of the joint instrument extend beyond mere interpretation of the withdrawal agreement and represent materially new legal obligations and commitments which enhance its existing terms. Turning, Mr. Speaker, to the unilateral declaration, it records the United Kingdom's position that if it were not possible to conclude a subsequent agreement to replace the protocol because of a breach by the Union of its duty of good faith, it would be entitled to take measures to disapply the provisions of the protocol in accordance with the withdrawal agreement's dispute resolution procedures and Article 20, to which I have referred. There is no doubt, in my view, that the clarifications and amplified obligations contained in the joint statement and the unilateral declaration provide a substantive and binding reinforcement of the legal rights available to the United Kingdom in the event that the Union were to fail in its duties of good faith and best endeavours. Mr. Speaker, I have in this statement and in the letter I have published today set out frankly and candidly my view of the legal effect of the new instruments the government has agreed with the Union. However, the matters of law affecting withdrawal can only inform what is essentially a political decision that each of us must make. This is a question, Mr. Speaker, not of the lawfulness of the government's action, but of the prudence, as a matter of policy and political judgment, of entering into an international agreement on the terms proposed.